I don't trust being, I'm not gonna have a fair trial at all. And the other one, I want to challenge the grand jury proceedings to make sure due process.
Okay, pause for a second. Did you catch that? The defendant is already signaling distrust in the process, claiming due process wasn't followed during the grand jury phase. That's a major red flag in courtroom drama. But here's the kicker. Grand jury proceedings are typically secret, and proving a due process violation is like trying to catch smoke in your hands.
Okay. After much negotiation and going back and forth with you and the state has agreed to settle this case for a lesser included aggravated assault. You understand that? That he has?
I understand this, right?
And that they would dismiss the aggravating kidnapping, aggravated robbery. Do you understand that? Good. And that also that we would go unagreed to the judge with a cap of 15 years, which means that the judge would have the full range of punishment. Could be probation, could be 2 years up to 15 years. You understand that?
Yes, sir.
You understand that by rejecting this, you are looking at first-degree felonies? You understand that, right? Okay. And that after much thought and going back and forth, do you want to accept or reject that offer?
Not accepting it.
Okay.
Rejecting a plea deal for aggravated assault, which would cap sentencing at 15 years max, while facing first-degree felony charges. That's bold. Really bold. Viewers, what would you do in this situation? Take the deal and gamble on leniency, or roll the dice at trial facing life-altering consequences? Drop your take in the comments.
Right here for continuance and to move forward as pro se, and that's what I would like to do. I'm aware of the risk and everything.
What do you need a delay for?
So I can get some motions filed.
So what? What did the motions say that need a delay?
The motion say that I wanted to file?
Yeah. What are you asking for?
One of them, I wanted to file for recusal because there's bias in this courtroom. I don't trust being...
Because there's Biden in this courtroom. That statement, whatever he means by it, just launched this hearing into another orbit. Whether it's a metaphor or mistaken identity, the court is now dealing with a defendant whose legal arguments are unconventional, to say the least.
Skipped and everything, and case has been dismissed, and I would just
What
rather...
case are you citing?
There was one with Hartman where the guy was falsely accused of interrupting the courtroom or whatever, and because the guy named Alfred wasn't sworn into the district attorney's office or whatever, they dismissed his case. Like, I got them all wrote down and everything. There's probably a few of them.
I'm familiar with it, but you're wrong on the facts. But what else do you have? What else?
I got the motion right here. I'm not happy with how my attorney's been doing stuff for me. Like,
Okay. You want to represent yourself? Okay, you can do that.
I want my pre-trial motions.
Do you understand all the consequences that are part of representing yourself? You have to know the rules of evidence. You have to know the procedure. You're going to be, and if you keep interrupting me, I'll hold you in contempt. Only one of us can
A
speak.
classic moment. The judge warns him about interrupting. And trust me, judges don't like being interrupted. Courtrooms are built on order, not chaos. And when a defendant talks over a judge, that's flirting with contempt of court real fast.
Case is over 2 years old. How long have you been thinking about representing yourself?
Since John West wasn't doing anything for me at all.
How long is, I'm asking timelines.
I wanted to do it April 21st, but y'all convinced me to take an attorney, and I didn't get to do anything I wanted to.
No, you can do anything you want, sir. The fact that Tom Burbank, an experienced attorney, is helping you is to help you, not to dictate anything. It's your life. You get to make the call. You want to represent yourself? Then you're entitled to do that. But in 20 years here, a defendant has never been successful, but that's your choice.
Then why did he tell me that I couldn't have any of my motions that I filed before he was appointed to be ruled on?
Well, if I could read his mind, I guess I would know, but how would I know what's on his mind on those? I don't know why he would say that. That's why you were supposed to be work. Why didn't you ask him that?
I did.
What did he say? I'm not going to answer you,
He said not going to be ruled on
sir.
at all. Like, I got certain motions that I filed that I wanted ruled on.
Okay, what?
The motion for dismiss, I wanted ruled on.
It's denied. I've read that. It is denied. It doesn't have a legal basis. What's next?
And then I want to ask why I filed a habeas corpus and was never brought to court for the bond reduction. My bond was changed from 400,000 to no bond without me being present in the courtroom without my
Okay.
knowledge.
All right, that it won't hold up this trial. A fact of a bond. We're moving forward. You're set for trial today. What next?
That ruled on my speedy trial.
It's denied. What's next?
My speedy trial motion is
It's denied. You're getting a speedy trial. Here we are.
I filed it over a year ago.
It's being granted today. We're moving forward.
All right.
We're going to try the case today. This is what you want. This is your time, and
I don't
make
feel
it
like I'm
wisely.
fair trial in this courtroom, but we need to go forward and that's fine.
Thank you. Okay. Yeah.
The judge just laid it out plain and painful. Representing yourself is a bad idea, especially in a serious felony case. Yet, the defendant insists. It's the legal equivalent of walking into a gunfight, holding a rulebook and a dream. Only a handful of self-represented defendants ever win, and even fewer survive unscathed.
And you understand you're a layman, and you're going to be starting with about a 3-touchdown lead for the prosecution, because you don't know these rules, and it's just like in a ball game. They have to be followed, or else you are going to be are not going to be on the same level. And that's what competent lawyers do, is make sure that your rights and the laws are followed, the rights are given to you and allowed, and that both sides receive a fair trial. When you're not capable of knowing that, I've been doing this for 40 some odd years in prosecuting, in defense work, judge, and defendants never come out ahead in that regard. Do you understand? Knowing all, as long as you know that, you're grown up. You can make your choice, but it's a foolish choice to make if you don't want him to handle the case. What I'm going to do, right? You don't want it.
I just want to make sure my rights are reserved. So.
You've made your decision voluntarily, knowingly, intelligently, and that's what you insist on.
Your Honor, I have all my trial notebooks. I'll bring that so that he may have. I'll have the law books that I use so that he has everything provided to him, and will be here if he has any questions.
All right. He'll be standby. He won't be representing you. He'll be standby. If you need to get some advice from him, he'll be close by. You ask for that, and I will decide how much time, but we're not going to delay the case. We're not going to delay on you going and talking to him over and over and over again. You want to represent yourself, that's the way to do it, or else it would take months to try cases. If you went and asked him every question on every question asked and every issue. But he'll be standing by. The court will allow you if it's proper, and that is the way it is done.
Dude, can I say something, please?
Yes.
So I think 3 weeks he's been appointed to me. I mean, that's not a whole lot of time to even really officially get stuff ready at all. Like for over 2 years, I had no representation whatsoever. Nobody helping me, no nothing. So, I mean, that's how I'm saying this.
Here's the emotional gut punch. After 27 months in custody, the defendant claims he's barely had help. Whether that's true or not, it speaks to a broader issue, how overwhelmed public defenders often are. One attorney mentions handling over 200 clients. That's not a defense. It's a warning sign about systemic overload.
I had gone over any of the discovery with him, and then Mr. Burbank got appointed. And then
John West when was John West appointed? I go back on July 7th. Where's Mr. West?
Right.
John?
Yes.
You were representing him?
Yes.
Back 2 years ago. Did you just disregard everything?
No, I talked to him several times back then. He didn't want to do anything. They wanted the offer, and I was like, "Yeah, it was set for trial docket."
Okay, y'all, when you set it for the trial docket, were you prepared to try the case?
I was prepared back then until he wanted a different attorney, and that's when I got off. And actually, I got off because we found out eventually that I represent a co-defendant on this too.
That's correct, Judge.
And so at that point, I had to get off of it. That's why.
When was that?
I don't remember when that was.
Well, help me out.
How long you been off?
Okay, so it's
Probably before that time.
there was somebody else.
Well, Ms. Manaldi was his attorney for a while,
Whenever I got off, whoever took over after me, I'm not sure.
but for 2 years you were representing him.
bad. I didn't hear you.
Oh, wait outside. Until found it. Hey, let me go. Wait outside. Let's go.
What happened? What was that?
I've been waiting. Everybody. And was that?
They something.
Yes, sir.
John West talked to me twice here at the courtroom, only offered me the 15 years. He only came and one time in jail. He brought no case file, no that time, nothing. He ain't shown me anything. I don't know. You might be confused with somebody else or something, but my only reason why he came and see me is because my dad called him several times. He came to see me the first time to jail ever, January 5th, 2024.
How many times would you say you've seen him?
Be honest with you, I wouldn't even.
Come on, you've got, but I represented people, and every time I went to talk to them, I noted it, but how many times did you say you spent so in 2 years?
Several times, because it was here at the courthouse.
10 times?
Less than 10 times. I wasn't 10 times. No, I wouldn't say that. I'd say probably 5, 6.
How much time would you say collectively? Is it normal over that period of time that you discuss things?
My clients, yes, sir. That's about normal. I mean, I don't see them all every week. I don't go to see every single client I have because I have 217
I
cases.
understand.
But yeah.
Everybody is important. They has to be prepared.
Yes.
I didn't see anything against me until Mr. Burbank was appointed to me.
When did that happen?
I still have.
And when was he appointed to represent you, sir?
Mr. Burbank,
Yes,
he
sir.
came and see me, April of April, a month ago. Only seen him 3 times. I haven't seen Discovery in full yet. Like, I've seen the police reports and heard of bits and pieces.
What discovery is it that you, Mr. West, what have y'all done? Come on, so he knows something about.
I've actually, Your Honor, I've given him police reports, so he knows exactly.
Is that true?
what everybody is saying.
Okay, why aren't you telling me that nobody's doing anything? They're providing you the discovery. Don't misinform the court.
I'm not misinforming you. I said he's helped me. He's been a big help compared to what the guy have done and everybody else has done. Like,
Okay, what is it that you need that you don't have
I like to
already?
see everything. I want to see Discovery in full.
Well, what is it what do you mean everything? What is it
The
that,
only thing that he probably hasn't seen, Judge, is the interrogation of the co-defendants, but we went over it. I've gone over telephone calls that Mr. Adams has made that are probably not exculpatory.
Mr. Laird, is that the discovery essentially what Mr. Burbank is talking about?
Yes, sir. There's some.
He's provided it to y'all, and he's provided it to you. There's not tons of stuff here, apparently. So
Last week we provided him with the jail calls that we discovered. We're going through his jail calls. So
what else is there that he hasn't received? Anything?
Nothing.
Nothing.
The only thing he hasn't seen, Judge, is,
Why would you say that you don't have anything when the lawyers, this prosecutor and your defense attorney now say they provided you everything they have?
It does have with everything. Nobody.
Okay, that's it.
Everything. No,
Okay,
not lying to nobody. I'm just trying to make sure that I get a fair trial.
okay. So you got the information according to them. I don't know what it is, but they say it is. All right,
we have close coming at 12:30.
all right.
I'll get you close.
You're up first. Case.
You're with you.
I'll speak to you for a minute. I'm very good.
Okay.
Okay, here. Thank you.